You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 3 of Based in Fact, a true crime podcast. I am Lisa O'Brien, and today I'm joined by guest co-host Rick Mullinax of Burn After Reading, the YouTube channel that started with a deep dive into the West Memphis 3 case and has expanded to shine a light on aspects of the shady social media coverage of true crime, including the disappearance of Maura Murray and the murders of Libby German and Abby Williams by Richard Allen in Delphi, Indiana. This is episode 17, State of Florida versus James Milton Dailey, part 1. Rick joins me today to talk about the case against Dailey, who was convicted and sentenced to death for the May 5th, 1985 murder of teenager Shelley Elizabeth Boggio. We'll talk about the case against Dailey, his trial, direct appeals, and early state post-conviction efforts up to the death warrant issued by Governor Ron DeSantis on September 25th, 2019. And thank you for joining me today, Rick.
Lisa, thank you so much for having me on. I have a general knowledge of this case, but I haven't deep dived it as you have. So I'm interested in learning more, and then also asking questions or offering my take on things. So thank you so much.
You're very welcome. Thank you. And Kyle was going to be joining us today. I don't know if something has come up for him, but hopefully he'll be able to log on and join us in progress. All right, so we're going to start with the case, and I said May 5th in my intro, but it's actually May 6th. I have May 5th on the brain. The victim in this case is Shelley Elizabeth Boggio. She was born July 9th, 1970, in Battle Creek, Calhoun County, Michigan. Her parents were Frank Leonard Boggio, who died in 1992, and Cheryl Darlene Eddie Gustafson, who died in 2003. Shelley was half Canadian on her mother's side. Shelley had four sisters. She has, five sisters. She has Sherry Renee, who died in 2018, twin Stacy Marie, who died in 2006, Myra, who remained in Battle Creek after her father moved the family to Florida, and then Brittany and Callie, who were both born after after Shelley died. She was a seventh grader at 16th Street Middle School, which is now John Hopkins Middle School in St. Petersburg, Florida. She did drop out. Her father had moved the family to Florida from Michigan in 1984, and Shelley missed a lot of school. Maybe she wasn't adjusting to the new school, and she ended up not going to school, which is unfortunate. And then her injuries cause of death were multiple stab wounds, asphyxiation from manual strangulation, and drowning. The perpetrators are James Milton Dailey, who was born June 11th, 1946, which makes him 39 years old at the time he met 14-year-old Shelley. Let's just let that sink in for a minute. He was born in Spokane, Washington. His parents were John W. Dailey, who died in 1965, and Grace Littlefield Dailey Davies, who died in 2016. He had three siblings, John M. Jack, who was an older brother, Joseph, who was younger, who died but we don't know when. And then a sister, Joan, who was born in 1952. He graduated from Manhattan High School in Manhattan, Kansas. He attended Kansas State University in Manhattan, Kansas for about a year, and then he dropped out when his father died. He joined the U.S. Air Force in 1965 in October. He went to training in electronics communications repairs and completed that training in August of 1966. He did have 3 tours of duty in Vietnam, but they were short tours. They were about 3 months apiece, from January to August 1968, and then 2 tours in 1969. He was made rank of staff sergeant in August of 1969, but then his military career went to pot, so to speak, because he ended up having a lot of Article 15 disciplinary actions, and that led to basically he was encouraged to take an honorable discharge in 1977. He was married once to Mary Kay Kuhn from 1966 to about 1976. His second marriage is not documented, and the identity of the second wife is unknown, but that's mentioned in his clemency packet. He has a son and a daughter. His son, James Michael, was born 1967. His daughter, Stacy Kay, was born 1969, making her 1 year older than Shelley. So again, people, let's let that sink in. He was an alcoholic drug addict. He's also manipulative, and that's my layman's opinion. His prior crimes included fighting, assault, DUI, and an aggravated battery in Pima County, Arizona in 1979. So James Dailey is not a little angel, loyal servant of his country, Vietnam veteran. And, that's one of the things, the first thing I thought when he says after we had they make it sound like he was in Vietnam forever.
Right.
He was there for 6 months and back home. He did go to the Philippines. He was in Germany, and I think he was in Korea. But, he was only in Vietnam for a very short period of time. And I don't personally believe that he would have been one of the people tasked with going out and finding bodies when they were bombing or when their base was bombed.
No.
So I think he's exaggerating because he was in communications and aircraft maintenance.
So you believe he was definitely embellishing?
I believe, yes, most certainly he was embellishing. And he wasn't out in the jungle on patrol. He was at a base where he took care of their airplanes.
Right. And why there's many great servicemen and women, who have served our country. I mean, there have been people who have served and have done some horrific things, whether we're talking about Oswald, if people do believe he is the one who shot JFK.
Mm-hmm.
And there are others where you can serve your country and still do bad things afterwards. It's not unheard of. I think we have to look at it as it's neutral. It's like there's good cops and bad cops, good judges, bad judges. It's just like with anything.
So, and I just, like I said, I think his service has been exaggerated, and it does a disservice to the people who, were there and they were in country. They were in the jungle, dodging landmines and snipers with a really difficult time because of what they did.
Right.
As opposed to being on a base and, maybe you were attacked, but you were there for 6 months and then you were somewhere safe.
And do you believe that embellishment is based on part of good PR to make him look better, plus mitigating circumstances when we look at certain things?
I think it is mitigating circumstances and make it seem like he's being targeted unfairly by the system.
I can see that.
His victim, of course, was Shelley Elizabeth Boggio, who was 14. His accomplice is Jack Edward Piercy Jr. His date of birth is May 13, 1955. He was born in Maryland. His father is Jack Piercy Sr., who died in 2005, and his mother was Sally Piercy Simon, who may or may not still be alive. He had a brother, Charles James, who was younger. He was killed at the age of 19 by a drunk driver with his wife, who was like 17, I believe. They had just been married a year. He has a sister Melody, a sister Georgia, a stepsister named Laura, and a stepbrother named Scott through, I believe, his mother's second marriage. He had a relationship with Martha Cupp, Cupp, which resulted in the birth of his son Justin, and then a relationship with a woman named Gail Bailey, and that resulted in the birth of a son whose name is not known, I could not find, and did not look very hard for. He also was an alcoholic drug addict. He's a con artist, and he's manipulative, and he's kind of a career criminal. And his prior crimes include theft, conspiracy to commit murder, although he didn't actually follow through in that case. But I believe he did testify against the dead guy's wife and get her convicted. And then drug dealing and possession, and the victim again was Shelley Elizabeth Boggio. My apologies. I don't know why I did that.
Happens.
I also have a Stacy on the brain. So the murder happened on May 6, 1985. The victim was Shelley Elizabeth Boggio, who was 14. On May 5th, Shelley and her older sister Sherry spent the day with friends at Sunset Beach in Pinellas County, Florida. Sherry and Shelley left at about 3 p.m. and went to her friend Stephanie's house. Now, while Sherry and Shelley were at the beach, Sherry says they weren't drinking. And they were just hanging out with friends. Shelley went to Stephanie's house to meet up with her twin sister Stacy. While the girls were hitchhiking, they ran into James Dailey, Jack Piercy, and Oza Shaw, who were apparently hanging out at the beach as well, and they picked them up. Shelley knew Dailey and Piercy. Sherry also knew them. Piercy had been to her house once looking for Sherry, but their father told Piercy he was too old, about 30, to be hanging around with teenage girls. After buying beer, wine coolers, and pot, the group drove around drinking and smoking pot until Shaw asked to be dropped off at Piercy's rented house in Seminole. From there, Dailey and Piercy went with the three girls to a bar called the Driftwood Bar, where they sat on the beach drinking and talking. So apparently, the beer, outside the bar, they were able to stay on the beach without trying to get the underage girls into the bar.
Right.
Dailey and Piercy weren't hitting on Shelley, but Stacy said they flirted with her, and she described Dailey as acting weird. Which he's a 32-year-old man, she's a 14-year-old girl. Do the math.
Exactly. That is weird.
It was after dark when they ran out of alcohol and tried to get on into the quarterdeck. Because the girls didn't have IDs, they were told to leave. They went back to the Piercy house where he lived with his pregnant girlfriend, Gail, and Dailey. Shaw was sleeping on the couch due to marital problems back in Kansas. The group hung out, smoking pot, and watching either an Alfred Hitchcock movie or the Alfred Hitchcock TV show, which had been revived during that time period. At about 10 p.m., Stacy, Stephanie, and Shaw were done partying, but the others weren't. Dailey, Piercy, Shelley, and Gail left the house for Sherry's rock disco or Jerry's rock and roll something after dropping Stacy and Stephanie off. Shelley used an ID that belonged to Gail to get into the club. While there, Shelley rebuffed Dailey's advances, choosing to dance with Piercy. It's disputed as to whether this bothered Gail at all or not. Some accounts, Shelley actually had Gail's permission, and by other accounts, she didn't. When they got home after midnight, Shaw woke up and asked for a ride to a payphone so he could check in with either his wife or his girlfriend back in Kansas. He also wanted to call and check in with whoever he was not planning on checking in with earlier, because he eventually made 2 calls. Piercy and Shelley drove him to the phone booth and waited for him briefly, honking the horn when he took too long. They left Shaw and drove away because he was taking too long. Whether Dailey was with him at this point is disputed. He claims he went to his room and went to sleep, but Gail claims that when she returned from the bathroom after their arrival at the house, Piercy, Shelley, and Dailey were all gone, and this upset her, perhaps because she was carrying Piercy's unborn son at the time. Piercy has claimed that he returned to the house and picked Dailey up after dropping Shaw off at the phone, which isn't implausible.
It does seem to make sense.
And Shelley was still with them. Shaw spent about an hour on the phone, then walked back to the house. Gail was still upset, and this is the other reason that I believe Dailey was not at the house, because Gail was upset, and Oza Shaw wanted to go back to bed, but he had to talk to Gail.
Talk her down.
If Gail was that upset, why would she not have sought Dailey out and looked in his room?
Yeah. Did they have a decent relationship where that could happen?
I'm not sure, because I think the move to Florida together from Kansas had been kind of, spur of the moment.
Mhm.
And I don't know, but I would think if she's alone in that house upset, she would go looking for somebody to vent to. And now it's never been established one way or the other. She never says she looked in his room, but that's kind of just my speculation.
That she would want to vent to somebody who would
Mm-hmm.
be a lending ear. Yeah.
Yeah. So anyway, when Oza Shaw got back, he tried to calm Gail down. Maybe he did, maybe he didn't. He ended up going back to sleep on the couch. At about 2 or 3 a.m., Piercy and Dailey returned to the house. So to return, one has to have left.
True.
Dailey was carrying his shirt. He wasn't wearing shoes, and his pants were soaked to the top of his thighs. Some witnesses described them as wet to the waist. Based on the autopsy report, it is clear that Dailey tortured Shelley, stabbing her 31 times, more likely than not when she said no to sex with him or when she fought off an attempted sexual assault. During the attack, Shelley sustained 18 defensive wounds to her hands and arms. And she fought for her life.
It's terrible.
There's no denying it. When the stab wounds didn't kill Shelley, Dailey threw her into the water, choking her and holding her head underwater until she stopped struggling. He and Piercy then returned to the house like nothing had happened. Later that morning, a bridge tender found Shelley's nude body floating in the intercoastal waterway. At the house in Seminole, Gail found some of Shelley's belongings in the car and removed them. The group decided to abandon Pinellas County and head to Miami. After a quick trip to a laundromat where Dailey and Piercy were observed talking in hushed tones, they headed to Miami. They checked into a motel or a hotel. There is some dispute as to whether Dailey was trying to hide his identity because he used J. Dailey, not James Dailey, when he checked into the hotel in Miami. The following day, Dailey abandoned the group and boarded a bus for Tucson, Arizona. Eventually, he made his way out to California and stayed under the radar for 6 months. Piercy returned to Olathe, Kansas, where he was arrested on May 21st, 1985. During a series of statements, he named Dailey as the killer. Piercy claimed he was asleep in the car and woke to the sound of Dailey murdering Shelley. Piercy was extradited from Kansas to Florida on July 17th, 1985. Dailey was eventually located in California in November of 1985. He was arrested and extradited to Florida on February 12th, 1986. Now, after After Piercy's statement, which we'll see later, Dailey's counsel somehow forget about this, but it is Jack Piercy's statement in Olathe, Kansas, that leads to Dailey even becoming a suspect in this murder. So please, folks, keep that in mind. A warrant and complaint for murder in the first degree was issued for Dailey on June 27, 1985. He was officially indicted on January 22nd, 1986. And then there was a complaint and arrest affidavit issued on February 11th, 1986. And that was all part of the extradition process.
Right.
He was finally extradited on the 12th of February to Pinellas County. I took Spanish for many years. I'm going to say Pinellas. My apologies to the citizens of that county if I'm mispronouncing it. Counsel was appointed to represent him on February 27, 1986. That was Henry Andringa, Andringa, Andringa. He was appointed due to a conflict created by the Public Defender's Office, which is likely but not confirmed to be prior representation of jailhouse witnesses against Piercy and Dailey. And first, we're going to talk kind of about Jack Piercy's case, and we're going to go through the whole process for him because it sort of shapes how things are going to play out. So we're going to go a little bit ahead in time, and then we'll come back to Dailey. So Piercy was charged under docket number 8507581 CFANO in Pinellas County, Florida. The judge was Thomas E. Pennick Jr. Counsel for the state were Robert Heyman and Beverly Andrews. Counsel for the accused were initially the Public Defender's Office, and then Ronnie G. Kreider and Kai Koch were appointed in October of 1985 through the trial. He had a similar warrant and complaint issued on June 17th, complaint and arrest affidavit on July 17th due to his extradition. He was extradited in July. He entered a not guilty plea on August 2nd, 1985, and he had several trial settings, but they were continued. In October of 85, the Public Defender's Office had to withdraw. They did not cite a reason other than conflict of interest, and they did not elaborate on what that particular conflict was, although I'm guessing they had other indigent defendants who would come forward as witnesses against both Piercy and Dailey, and therefore they couldn't represent Piercy and Dailey.
That seems to make the most sense. I would be surprised if there was another reason.
Yeah. So, but again, I have to speculate because nothing is enumerated in any of the pleadings.
It's not officially documented. I understand.
Correct. And that's not unusual when there's a conflict of interest involved. They're generally not required to, if anything, they're required to provide a sealed explanation, but it never sees the light of day. So then the motion withdrawal was set for hearing on October 21st, and that hearing was held. The motion was granted, and the court held a hearing on October 25th on the motion to appoint private counsel because they didn't have a public indigent defense alternative to represent Piercy. And the similar proceedings were probably held in Dailey as well, although they're not as documented. But they now will appoint private attorneys. We do that. That happens in Louisiana as well. And they appointed Kreider and Koch to represent Piercy on October 25th, 1985. They filed a notice of appearance, a demand for a copy of information, a plea of not guilty, and a demand for discovery on October 4th. Even before being involved, or that's in the wrong place. I'm sorry.
Right.
The trial was reset for June 24th, 1986. And then on June 30th, 1986, Piercy filed a motion to suppress confession and or admissions. His reasoning was the state had failed to provide videotapes of interviews conducted in Olathe, Kansas after being ordered to do so by the court, and a motion for sanctions was pending. The Florida detectives obtained admissions from Piercy on 2 occasions after he invoked his rights to counsel and to abstain from self-incrimination. A polygraph was administered at the request of the state's attorney without counsel present, and further admissions were obtained by the polygraph operator against limitations that had been imposed by Piercy's counsel. And jailhouse informants were acting on behalf of the state, and Piercy's admissions to them were obtained illegally. The state filed a statement of facts on July 22nd, 1986. His indictment was reissued on October 22nd, 1986 for murder in the first degree. And then Piercy files a protective order, or a motion for protective order, on October 23rd. And in that, he asks, and this is probably out of date again, I apologize.
That's all right.
Dailey's testimony would exonerate Piercy. It's critical to Piercy's defense that Dailey testify without fear that his testimony would be used against him. Dailey has made statements to inmates at the Pinellas County Jail that Piercy did not kill Shelley, and Dailey could substantiate those statements, and Piercy will be denied due process of law without the court issuing a protective order that allows Dailey to testify truthfully without the threat of his testimony being used against him. Now, just to fill people in, what this is this is evidence, at least to me, of Piercy and Dailey playing some games with the system.
So you do believe they're working in tandem with this?
Yes, I
Okay.
believe the substance of the statements that these inmates are talking about is Piercy and Dailey were going to exonerate each other. So what's going to happen is Piercy's going to go to trial. He's going to get convicted, but he's going to get a new trial. Dailey's going to be acquitted, and then Dailey's going to testify at Piercy's new trial that he killed Shelley, not Piercy, and Piercy's completely innocent. And then Piercy gets acquitted. That was the substance of their plan. That was the substance of the statements that these inmates were testifying to being made, in addition to incriminating statements about the murder itself. And they were using inmates to pass these messages back and forth.
Now, also, when I say Dailey and Percy, does that also include, I would assume so, their legal team working in tandem together as well?
No.
No. Okay.
This is one of the instances, I think, if the attorneys had known that these are the games the boys were playing, they would have told them to stop. Because all it's ever going to do is come back and bite you on the ass.
And how, I don't know if it's easy to say more or less, but how common is it to see something like this in a murder case for a motion for a protective order, especially when there's more than one person involved?
It is not common at all, and it's a very interesting thing that these attorneys tried to do. Basically, they want to insulate Dailey from having testimony used against him. But again, I think this is because Jack Piercy said, he did it. He's willing to testify for me, but he doesn't want his testimony being used against him. What can you do?
Right.
And the attorney's like, well, we could try it, but it's not going to work. Spoiler alert, it's not going to work.
Yeah, that's interesting, the game playing there, because I was interested if the attorneys were involved in that, but it makes sense to what you said, and the fact that they would say stop it, but not all defense attorneys, public defenders are always honorable either. When we talk about good and bad, they'll just use whatever strategy.
Right, and like I said, I don't think, because this started when they were in the jail.
I see.
And so, they sold it. Piercy's very manipulative, and I think Dailey is equally manipulative. And I'm going to tell you something right now. I don't believe that Dailey was in Piercy's thrall. I think it was the other way around. Dailey's the older guy.
That's true. That makes sense.
Piercy's 9 years younger. He's not leading Dailey around. He's following Dailey's lead. And I think that's probably true of everything. I think the idea to go to Miami was not Piercy's, it was Dailey's. But you saw, if anybody's watched the Perfect Liar 2020 episode, Dailey, it seems like this little meek, mild, wouldn't hurt a fly guy. But, he's got a reputation for fighting.
And they make Percy seem like the alpha of the group, don't they?
Right. Yeah, they do. They
Yeah.
make him seem like the alpha. And Dailey is 6'2". I don't know if you noticed that because they only filmed him standing up a couple times. But he's a big guy. And Piercy was like 5'9", 5'10". So
that's interesting.
So anyway, all right. So we're going to go through Piercy's case. So the motion to suppress was denied on November 18th, 1986. A hearing was held. An order also denying the protective order was issued on the same date. Piercy's trial was a jury trial. I saw something about him in some article about he pled guilty. No, he did not plead guilty. He went to trial. He was convicted guilty of first-degree murder on November 22nd, 1986. His penalty phase was held. His jury elected to sentence him to life without the possibility of parole, which has a 25-year mandatory minimum. So there's not really no parole in Florida. He filed a motion for new trial on December 2nd, 1986. His judgment and sentence were entered on January 8th, 1987. He filed a notice of appeal and then amended it on January 20th, 1987, although I can't tell the difference between the initial notice and the amended notice. He filed his direct appeal was affirmed per curiam on December 2nd, 1987. It's unpublished. The mandate issued on December 21st, 1987. He did not, as far as I could tell, appeal to the U.S. Supreme Court, so his conviction and sentence became final. His post-conviction 3.850 motion was denied on December 11th, 1989. He filed a motion for a rehearing pro se on December 21st. He also filed a notice of appeal on January 8th, 1990. An order was issued granting the motion for rehearing. And then on March 28th, 1990, post-conviction relief was denied. Notice of appeal was filed on April 17, 1990, again pro se, to the Second District Court of Appeal. The post-conviction denial was affirmed on August 3rd, 1990, again in an unpublished opinion. Mandate issued on September 24th, 1990. He filed a motion for rehearing, and that was denied on April 18th, 1991. He filed a petition for writ of habeas corpus in the appeals court. That was denied on December 5th, 1991. The mandate issued January 28th, 1992. And so that's the end of his post-conviction. In Florida, a lot of state prisoners don't file, and I didn't find anything filed in federal court for Jack Piercy. I think part of it is because I think he was doing this pretty much pro se. So on March 19, 1993, he gives a sworn statement to an attorney working on behalf of Dailey at the prison at Stark, exonerating Dailey.
Really?
Yeah. We'll talk about that. This is an extension of their game. We'll talk about it a little bit more in depth next episode.
Okay.
Because we'll talk about it in context with Dailey's claims.
Okay, understood.
He filed a motion for DNA testing. He filed 3 motions for DNA testing. One was before the DNA testing law was issued. One was at the same time. And then the third one was on September 29, 2003. DNA testing was denied. He sought testing on blood on his gray and black shirt and the passenger side floorboard of the vehicle. And that was denied. He was alleging that it would be animal blood, and not human blood. Because in 1985, I don't know if they even, I didn't find anything that they ever tested any of the blood to figure human, animal, anything.
Right.
But all they would have been able to do was serology. An opinion affirming that denial was issued on December 29, 2004. On April 20th, 2017, Piercy signs an affidavit that Dailey was not present when Shelley was killed and Piercy is responsible for her death. That was on a visit from Dailey's attorneys. A hearing was held on January 3rd, 2018, and at that time, Piercy refused to testify on behalf of Dailey. He basically said that statements in the affidavit were untrue, but he would not testify. He pled the fifth. He was visited on December 18, 2019 by Josh Dubin at the Sumner Correctional Institution. Apparently there he made admissions to Dubin.
And explain to people who Josh Dubin is.
Josh Dubin is an attorney who works with the Innocence Project, who fancies himself a crusader for the wrongly convicted, and who really, I mean, aside from getting one guy out of prison, I don't think his record, again, we'll speak about it more next episode, in context of Dailey's case, is not that great.
And I would just like people to know, if you ever hear or watch Josh Dubin, if you hear him speak, it is only rivaled to what I would call absurdity, the over-the-top absurdity of a televangelist.
Yeah, over dramatic.
Very.
He's like Bob Ruff with a law degree. You can find on YouTube. There's a hearing that was held on March 5th, 2020, and you can find that on YouTube and watch him in action. We'll talk about that too a little bit more, in the next episode.
Okay.
Anyway, on December 18th, 2019, Piercy signs a declaration that says Dailey had nothing to do with Shelley's murder. Piercy committed the murder. Dailey was at the house when he drove Shelley to the place where he killed her. And then a deposition was taken on February 25th, 2020, and that too was taken at Sumner Correctional Institution in Bushnell, Florida, by Josh Dubin on behalf of Dailey. Prosecutor was there, but we'll talk about that again a little bit more. These are events that have occurred in a thumbnail, and we'll talk about them more in depth in context with Dailey's case.
Okay, so we'll get more context of why Piercy is making these statements, and
I'm really trying hard not to spoil it.
I understand. Okay.
And then that hearing, as I mentioned, which is available on YouTube, and I have no issues if people want to go look at that and see Dubin in action and see Piercy in action, because there are some very interesting statements made during that hearing. All right, so now we're at State of Florida versus James Milton Dailey, and that is under docket number 8507084 CFAN0ANO. It's in the Circuit Court of the 6th Judicial District in and for Pinellas County. The judge was the Honorable Thomas E. Pennick Jr. Henry Andringa was appointed after the after the whatever indigent defense, public defender's office, whatever they're called, he filed a notice of appearance on March 4th, 1986. It's a notice of appearance, demand for copy of information, plea of not guilty, and demand for discovery on March 4th, 1986. Dailey was arraigned on March 24th, 1986, and pled not guilty. His trial was set in August, December, April of 87, and June of 87. 4 times his trial was set and continued. A couple times for state, a couple times for Dailey. On July 22nd, 1986, there was an order entered compelling head hair, blood, and pubic hair samples from Dailey. So it looks like they were comparing something, although nothing ever came of it. The trial was held in the same 6th Judicial Circuit, same judge. The counsel for the state were Robert Heyman and Beverly Andrews. Counsel for the accused were Henry J. Andringa, James W. Denhart, and John E. Swisher on sentencing. Guilt phase began on the 23rd of June, 1987, and concluded on June 27th. He was found guilty of murder in the first degree. The penalty phase was June 27th to June 30th, and at that time, death was recommended by his jury 12-0. He filed a motion for a new trial on July 8th, 1987. A judgment and sentence was entered on August 7th, 1987. And Florida at this time was a little different from most states. In Florida, the jury made the recommendation, but the judge ultimately determined aggravating circumstances and mitigating circumstances and weighing those to determine whether a death sentence recommendation was going to be honored or not. I believe, I could be wrong, but I believe that if the jury recommended life, the judge gave life. And it was only if the jury recommended death. And if the jury recommended death, the judge also had discretion to find life.
And hopefully I'm not jumping ahead, but even Dailey even recommended he wanted a death penalty, correct?
Yeah, that's an interesting thing. I think he kind of alluded to that in that letter that I found.
Mm-hmm. That's how I read it. Yeah.
I don't find anything in the sentencing memorandum or the sentencing order issued, findings in support of the sentence issued by the judge, that, well, no, I take that back. I did find that he did ask for it.
Mm-hmm.
But I don't find any pleadings or anything where that is put to paper. It may have been in the transcript.
Right.
It may have been at the hearing.
And it was just interesting, the fact that he would just, he would want it. He would recommend it for himself, despite any of the legalities with that. That's something he wanted.
Yeah, but for something he wanted, he sure is trying really hard to avoid
Mm-hmm.
it. As we'll see.
Mm-hmm.
So, all right. So the judge issued his findings in support of sentence on September 2nd, 1987. And I want to go through his findings. Well, no, I'm not going to go through these because these are not, they didn't stick. So I won't go through these. We'll skip these.
Okay.
But he did honor the jury's recommendation and sentence Dailey for the to death for the murder of Shelley Boggio. A notice of appeal was filed on September 4th. That went to the Florida Supreme Court, docket number 71,164. He was represented by A. Ann Owens and James M. Moorman. The issues he raised on appeal were whether the trial court erred in allowing the state to introduce evidence that appellant resisted extradition, whether the trial court erred in failing to conduct a Richardson hearing before allowing admission of a booking photograph taken of appellant at the time of his arrest, I'm not quite sure what the controversy was about those pictures, whether the trial court violated appellant's right to confrontation by omitting testimony of out-of-court statements made by a non-testifying co-defendant, whether the trial court erred in admitting a knife sheath into evidence and allowing testimony concerning its discovery, where the state allegedly failed to connect the sheath either to appellant or to the crime, whether the trial court erred in allowing Detective Halliday to testify to prior consistent statements made by 3 inmate witnesses, whether the trial court erred in prohibiting defense counsel from inquiring into the details of Paul Skalnick's past and pending felony charges, whether the trial court erred in giving the standard jury instructions by stating that appellant did not have to be present when the crime was committed to be guilty of first-degree murder, whether the trial court erred in denying appellant's motions for mistrial based upon alleged comments by the prosecutor on appellant's failure to testify or to present a defense. Because as I recall, he didn't present any witnesses. His defense rested when the state rested their case.
I see.
Whether the trial court erred in qualifying Detective Halliday as an expert in homicide and sexual battery investigations, where his opinion was based on nothing more than common intelligence and speculation. Whether the trial court erred in finding 3 aggravating factors not supported by the evidence and in considering a non-statutory aggravating factor during his discussion of possible non-statutory mitigators. Whether the trial court erred in admitting into evidence a certified copy of appellant's prior conviction for aggravated battery, which contained a notation at the bottom stating that pursuant to the plea agreement, another charge had been dropped. Whether the trial court erred in failing to consider statutory and non-statutory evidence in mitigation. And finally, whether the trial court violated appellant's confrontation rights by basing his sentence in part on extra record information gained from the co-defendant's trial, the co-defendant's pre-sentence investigation, and the prosecutor's sentencing memorandum. The Florida Supreme Court issued their per curiam opinion on November 14th, 1991. Procedural posture defendant appealed from the circuit court in Fort Pinellas County, Florida, which convicted him of first-degree murder and sentenced him to death. Defendant was convicted of first-degree murder and sentenced to death. He appealed his conviction. The court affirmed the conviction, reversed the sentence, and remanded for resentencing before the trial judge. The court found certain evidence regarding defendant's effort to avoid extradition should have been excluded, but the error did not affect the verdict. The court also found no error in allowing evidence of a photo taken of defendant over defense counsel's objection for not having been provided with the photo during discovery. Regarding his penalty, the court found the lower court erred in finding as an aggravating circumstance that the murder was committed to prevent a lawful arrest. The evidence also failed to support the finding that the murder was committed in a cold, calculated, and premeditated manner. In considering evidence from a different trial that was not introduced in the guilt phase of the present trial, the trial court also deprived defendant of the opportunity to rebut this proof. The court affirmed the conviction, but reversed the sentence and remanded, finding that the lower court erred in finding as an aggravating circumstance that the murder was committed to prevent a lawful arrest. The evidence also failed to support the finding that the murder was committed in a cold, calculated, and premeditated manner. And one judge concurred in the guilt phase and concurred in the result only as to the penalty. But he didn't issue an opinion further explaining. There was a motion for a hearing filed, and that was denied on March 19, 1992. It was filed by actually both the state and Dailey. Probably the state was trying to get them not to reverse the sentencing. The mandate issued on April 22nd, 1992, and an order denying, and it went back to the trial court. There was an order issued on December 2nd, 1992, which actually should have been further down, denying the motion to disqualify, because the first thing Dailey does is he tries to get the trial. He wants to just disqualify the trial judge. So it returns to resentencing. By this time, the state's represented by Bernard J. McCabe. It remained before Judge Pennick, and John E. Swisher took over as the sentencing attorney for Dailey. He did file a motion for a penalty phase trial, which would mean seating another jury. That was denied on May 18, 1993. He also tried to disqualify the trial judge. So I think he tried to disqualify the trial judge in the Florida Supreme Court, and they denied. And then he filed a motion in the trial court, and that was denied on July 15th, 1993. On July 26, 1993, the Florida Supreme Court struck a notice of appeal, granted a motion to strike notice of appeal, and it's ordered that the notice of appeal filed in the above case is stricken, and the same is hereby dismissed. And that was trying to appeal denial of the penalty phase trial and disqualification of the judge.
Okay.
And so the resentencing hearing was held between December 9, 1993 and January 21st, 1994. That may not have been continuous. It was kind of hard to tell whether it was December 9th, 10th, 11th through the 21st, or whether it was various days over the course of that period. A resentencing order was issued on January 21st, 1994, and now I'm going to go through the aggravating factors and the mitigating factors and the court's findings or reasoning. And the reason I'm going to do that is because later on, we will hear allegations that it was the testimony of a jailhouse snitch. Hello, Kyle. Thank you. We missed you.
Hey, good afternoon. Sorry, I think I got my time zones off. My apologies.
No worries, no worries. I was so happy when I saw you there. So we're being joined by Kyle. Yay!
Good afternoon, everybody. Sorry.
Good afternoon, Kyle.
Yeah,
all right,
hey, Rick, how are
so
you?
we've
Doing
gotten
good, thank you.
to Dailey's resentencing, which is on page 16.
No, excellent. Thanks.
So that's where we're at now, and I want to talk about it because, as I was saying, there's a lot of allegations that it was a jailhouse snitch who put James Dailey on death row, and that simply isn't true. That's overblown and overdramatic. What put James Dailey on death row is stabbing Shelley Boggio 31 times and choking her and then holding her underwater until she drowned. That's what put him on death row. Spoiler alert. So the aggravating factors found by the judge were the defendant was previously convicted of another felony involving the use or threat of violence to the person. The capital felony was committed while the defendant was engaged in the commission of or attempt to commit sexual battery. The capital felony was especially heinous, atrocious, and cruel. Now, the mitigating factors listed by the court were that the capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. The court held that there was some evidence that in years past defendants suffered from a drinking problem and that this problem was exacerbated by his Air Force duty during the Vietnam War. That evidence rose to a level no higher than bare allegations. There was no evidence presented of any nature or kind which established extreme mental or emotional disturbance of the defendant, which would mitigate against or outweigh the established aggravating circumstances. The next mitigating factor is the defendant was an accomplice in the capital felony committed by another person, and his participation was relatively minor. The evidence presented through all stages of the trial established beyond a reasonable doubt that Dailey was the major participant in the stabbing, beating, choking, and drowning of Shelley Boggio. His participation was not minor. It was major and the cause of her death. This mitigating factor does not exist. Dailey's own statements to fellow inmates at the Pinellas County Jail establish him as the major participant in the murder. Dailey admitted he stabbed the victim numerous times and felt frustration that no matter how many times I stabbed her, she would not die. Witnesses presented corroborating evidence that Dailey played a major role in the death of Shelley Boggio. Gail Bailey and Oza Shaw testified Dailey returned home wearing wet pants and no shoes. This is consistent with Dailey having physically held the victim underwater until she drowned. Third is the defendant acted under extreme duress or under the substantial domination of another person. The judge held there is absolutely no evidence in the record of this trial which indicated that any person had domination over Dailey and caused him to commit the capital felony. The evidence proved beyond a reasonable doubt that Dailey stabbed, beat, choked, and drowned the victim. This mitigating factor does not exist. The fourth is the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. Again, the judge held there was no evidence presented in this trial that the defendant was substantially impaired by alcohol or drugs. There was some evidence that Dailey had gone to a bar on the night of the murder. There was absolutely no evidence that he was intoxicated. There was testimony that Dailey used marijuana on the night of the murder. However, there is no evidence that he was under the influence of anything to the extent that he was so substantially impaired that he could not appreciate the criminality of his conduct. Both Gail Bailey and Oza Shaw saw a defendant before the murder and after the murder. Neither witness indicated that the defendant was under the influence of alcohol or drugs to the point where he was unable to control his conduct. Dailey's ability to relate with clarity and specificity the events surrounding the murder of Shelley Boggio to inmates of the Pinellas County Jail establishes the fact that he was not under the influence to the extent that he was so substantially impaired that he could not appreciate the criminality of his conduct. Therefore, this mitigating factor does not exist. Now, the non-mitigating, the judge found that the defendant was in service and was involved in 2 or 3 tours of duty in Vietnam. The incident occurred while the defendant was intoxicated, and he developed a problem with alcohol as a result of his military service in Vietnam. Evidence was presented that the co-defendant, Jack Piercy, may actually have been the perpetrator of the homicide. The defendant was good to his family, helpful around the home, and never showed signs of violence. Other non-statutory mitigating factors would be the fact that he participated in saving the lives of 2 young people at an early age. And because of the alcohol problem and the heavy drinking the night of the offense, evidence was presented that the crime for which the defendant is to be sentenced was committed while he was under the influence of extreme mental or emotional disturbance. This was supported by the fact that he had prior history of being admitted for treatment in regard to his alcohol problem. It is not necessary to show that the defendant is insane to qualify for this standard. The court held on 1 and 2, the fact that Dailey served in the Air Force and saw duty in Vietnam on 3 occasions is commendable. Thus, the court gives some weight to this non-statutory mitigating factor. However, the record is void of any credible evidence that Dailey had an alcohol problem, let alone an alcohol problem directly attributable to battle stress or clinically labeled Vietnam syndrome. Thus, this mitigating factor does not exist in this case. As to number 3, Dailey asserts that there was evidence presented that another person may have been the perpetrator of this homicide. The evidence presented in this trial does not support his assertion. Dailey's own statements, no matter how many times I stabbed her, she would not die, vitiate this claim. Additionally, as discussed in paragraph 3 of the statutory mitigating factors, witnesses testified that Dailey returned home wearing wet pants and no shoes. The evidence proved beyond a reasonable doubt that Dailey caused the victim's death. The court considered this mitigating circumstance but gave it no weight. Number 4, the fact that Dailey was good to his family and helpful around the house deserves recognition by the court. Dailey cared enough for his daughter to allow her to be adopted by his Air Force buddy when his friend married Dailey's ex-wife. These mitigating facts were given partial weight by the court. However, the statement the defendant never showed signs of violence is a gross misstatement of fact. The statement may have been made to indicate no violence toward his family, but as discussed in paragraph 1 of the aggravating factors, Dailey was convicted in 1979 in Pima County, Arizona for aggravated battery. Therefore, the court gave little weight to the non-violent factor of this non-statutory mitigating circumstance. 5, the court gave some weight to the mitigating factor that Dailey saved 2 young people from drowning when he was in high school. However, the saving of 2 people from drowning does not alleviate the seriousness or mitigate the subsequent criminal act of causing the death of a young person by drowning. Number 6, again, Dailey asked this court to consider that Dailey was under the influence of extreme mental or emotional disturbance and suffering from an alcohol problem as a statutory mitigating factor and a non-statutory mitigating circumstance. The crux of this non-statutory mitigating factor is that Dailey's use of alcohol resulting from his tours in Vietnam and over a period of time has taken a toll on Dailey's mind and body. In this case, Dailey has not shown those circumstances to exist. The witnesses who testified about Dailey's appearance and condition when he returned home on the night of the capital felony did not describe him as being intoxicated, under the influence of any substance, or suffering from any mental or emotional condition. Fellow inmates who testified at Dailey's trial testified that Dailey's recollections of the circumstances on the night of the homicide were clear and detailed, not confused or unbelievable. The court gave some weight to the fact that Dailey and the victim had been partying and visited some bars together on the night of the capital felony. However, the court does not give much weight to this non-statutory mitigating factor. The court has very carefully considered and weighed the aggravating and mitigating circumstances found to exist in this case, being ever mindful that human life is at stake in the balance. The court finds, as did the jury, that the aggravating circumstances present in this case outweigh the mitigating circumstances present. Accordingly, it is ordered and judge decreed that the defendant, James Dailey, is hereby sentenced to death for the murder of the victim, Shelley Boggio. The defendant is hereby committed to the custody of the Department of Corrections of the state of Florida for execution of this sentence as provided by law. May God have mercy on his soul. So those are the statutory. So that has little, if anything, to do with any of the inmates who testified. And next week, I'm going to summarize their testimony when he's challenging one of them. So we'll get into that a little bit more. So any thoughts, any questions?
Yeah, the whole thing with mitigating circumstances is always kind of quizzical for me personally as a layman, because and maybe this happened and I just don't know. In Ted Bundy's case, you know, he worked on a suicide hotline and talked a lot of people out of suicide. What does that have to do with the horrendous crimes that he committed? It shouldn't have any bearing at all. Right?
Well, this is something, this is a factor. It's to give the criminal defendant a chance at something other than death. And you might find, not necessarily for a Ted Bundy, but for, say, somebody who's not as heinous.
Someone who committed one crime compared to a number of crimes.
Right. And you know, you could say a James Dailey if the victim was an adult woman.
Mm-hmm.
Then it might give, and he hadn't drowned her. You know, it might have given, and this is for the trier of fact to weigh. Do these mitigating factors outweigh? You know, has he lived an exemplary life and then he got into drugs and drinking and went off the rails.
And I completely understand the legality. It has to be considered. I just mean still just from a layman's perspective, if you are the victim's family or something like that, you don't really care what they did before because he stabbed her 30 plus times. She would not die, and so I will strangle her underwater. Like, to me, like, any goodness you've ever done at that point means nothing.
Right.
So
That's probably why you and I will never make it onto a death penalty jury.
probably not, no.
Because we're not as forgiving
Right.
of, bad behavior as, other people may be. But yeah, it is something, and again, it's a case-by-case basis.
And that's true too. Like, it depends on what the situation is. I understand in this, it still has to be considered for every case, and perhaps that's not a bad thing. Another example I could think of is like Chris Benoit. A lot of people talk about the good stuff that Chris Benoit did. He was a professional wrestler, and how good of a person he was up until the point that he committed the double murder suicide.
Yeah.
And I'm like, look, whatever he's done in the past doesn't really mean anything to me. It's what he did at the very last day of his life. And he killed his wife, he killed his son, and then he killed himself. And that's it for me. But people still want him in, like WWE. I understand, it's all predetermined, but they want him in the Wrestling Hall of Fame. They want him in the WWE Hall of Fame because they feel like one circumstance should not judge the rest of his life. And I disagree. I say yes. Like, that one thing, it completely dissolves any good things that you've done or any talented things that you have done.
Was he, though, ultimately found to have had CTE?
See, CTE is still something that, yes, he had it, but there were other circumstances that were going on. And so while he may have had CTE, there were other things that were going on in his relationships with his wife, Nancy. And also his wife before, there were a lot of other threats. And she said, if I die, it's, it's because of him. So there was already
that may have been the underlying cause for these problems.
And
because the CTE has that dramatic 180-degree personality change.
And it happens. Can. And it is possible. It's just that there's a lot to still learn about CTE. And there's also a lot of athletes who have CTE, which you can only really know if they have CTE, but definitively through actually, they got to slice up the brain. They have to analyze it and study it. And there's a lot of athletes that don't have that. It's kind of like saying everyone who's a psychopath commits murder. Well, we know that's not true, but we know that can be a determining factor to doing something.
Right.
By doing that, or anyone who's schizophrenic, or
although hopefully I think they've been working on imaging CT, MRI, because there's a protein that I think they're working on, hopefully being able to pick up in some way so that maybe they can treat the damage and prevent the worsening of the condition.
That would be great.
Yeah.
And honestly, the other thing too, and I could be wrong, I don't have like the stats and the studies in front of me, but it almost seems like with CTE, where suicide is more prevalent than homicide.
Yes. But it can lead to, because it's a personality, but a lot of times it's a personality problem, a personality change occurs, and then they start self-medicating with drugs or alcohol. And that leads to volatile behavior. And that can lead to volatile behavior directed outwards towards others or directed inwards. And I think the majority it does end up being suicide because they can't deal with it anymore. but occasionally it is assaultive behavior. Aaron Hernandez, although I think Aaron Hernandez was a little bit wanted to be the gangster.
He did. And, these people too, they lie. And even despite having CTE, for example, like when you look at some of the former Steelers players, like they don't really understand what's happening to them. They know that something is. I mean, you had one guy that had to tase himself just to go to sleep. And with Chris Benoit or Aaron Hernandez, they commit a crime and they are concealing that crime too. So they know that they did wrong. So they're not so out of their mind that they don't know the difference between, reality and fiction or delusions. They are committing premeditated murder. And because Chris Benoit was calling the company just saying, me and my family, we have food poisoning. So I'll have to come in, to a show later, but I'll take care of this and then I'll come in. And so like he's covering up his crimes very deliberately, very precisely. And look, CTE, there's with the brain itself, it's a mystery.
Yeah.
There's a lot we don't know about it, but all I can tell is that this wasn't just a guy who was going through these delusions. He did things, he covered it up until the very end, until he could take care of himself. And Aaron Hernandez, he committed the crimes. I mean, it started with, or it ended with Lloyd, but there were other things that happened before too, and he knew, and he knew, but yeah, I didn't mean to go off base with that, but the point I'm trying to make is that when we look at these mitigating circumstances, just as a layman, to me, it's like I always look, if you do a horrific act, to me personally, I don't really care what you've done. I'm not going to honor the things that you've done. I'm not going to look at Hitler as a good guy because he was good to animals.
Right.
And we should be good to animals.
Yeah.
But, yeah.
All right. So now, second direct appeal after resentencing goes to the Florida Supreme Court, and the docket number was 83,160. On May 25th, 1995, a per curiam opinion was issued. Appellant challenged his death sentence imposed upon remand for resentencing by the Circuit Court in and for Pinellas County, Florida, for his conviction for first-degree murder. Appellant claimed that the jury's recommendation of death was invalid, that the trial court failed to find and weigh mitigating circumstances, and that the trial judge erred in failing to disqualify himself on the remand for resentencing. Appellant challenged his death sentence imposed upon remand for resentencing for his first-degree murder conviction. The court affirmed the sentence. The court rejected appellant's claim that the death recommendation was invalid because the original jury was given vague instructions on 3 aggravating circumstances, and the jury was instructed on 2 aggravating circumstances that were struck in a prior appeal. The court ruled that because appellant did not raise vagueness in his initial appeal, the recommendation was unchallenged and intact, and the trial court merely complied with the court's directive to hold a new sentencing phase. Furthermore, the court ruled that because he did not object to the instruction at trial, appellant was barred from raising the claim on appeal. The court then ruled that the recommendation was not presumptively invalid where 1 aggravating circumstance was struck on appeal and 3 others were approved. Finally, the court ruled that the record supported the finding that no mitigating circumstance existed and that the trial judge was not required to disqualify himself on remand merely because he had imposed death the first time. The court affirmed appellant's death sentence. The court held that appellant's failure to raise at trial the issue regarding alleged vagueness in the jury instructions on aggravating circumstances barred him from raising the claim on appeal, that the record supported a finding of no mitigating circumstances, and that the trial judge was not required to disqualify himself when the case was remanded for resentencing. And this is important because, in a few years from now, they'll be pretending that this opinion doesn't even exist. Rehearing was denied on August 22nd, 1995. The opinion was released for publication on the same date, and he appealed to the United States Supreme Court, docket number 95-6801. That petition was filed on November 20th, 1995. It was denied on January 22nd, 1996, and that is when his conviction and sentence became final. So then we moved to state post-conviction. Dailey, an attorney, filed an initial motion to vacate on behalf of Dailey in the trial court. That was on April 1st, 1997. Dailey signed a verification for that motion on March 27th, 1997. He requested an evidentiary hearing that he be allowed to proceed in form of paupers, which means he didn't have to pay any fees or costs, that he be provided necessary funds with which to obtain expert witnesses and investigative resources in order to properly present his claims, and without which no full and fair hearing can be conducted, that he be provided subpoena power for the production of witnesses and full and fair pre-hearing discovery, that he be allowed an additional 60 days from the date of disclosure of public records to amend the motion, that he be allowed leave to supplement the motion should new claims, facts, or legal precedent become available, and on the basis of the reasons presented herein, and that his convictions and sentences, including a sentence of death, be vacated. An amended motion to vacate was filed on November 12th, 1999, so it was a good 2 years. During that time, he made multiple public record requests, and I didn't go into all those things because we're at 52 pages, and that's just with the basic facts.
Mhm.
So he was represented on appeal on state post-conviction initially by Terry Backhouse, Carol M. Dittman, C. Marie King, and Eric C. Pinkert of the Capital Collateral Council, who is another indigent defense for state post-conviction, and I believe federal post-conviction. Okay, I'm going to go through the grounds for his initial state post-conviction because we're going to hear variations of these things in the future, and I just want to show he's raised this before. First ground, Dailey's counsel was prejudicially ineffective at the guilt phase of the trial in violation of the 6th, 8th, and 14th Amendments to the United States Constitution for failure to object to prosecutorial misconduct during opening and closing statements, failure to adequately cross-examine and impeach Gail Bailey, failure to adequately cross-examine Deborah Steger, who was a forensic examiner, failure to utilize testimony, failure to move for a change of venue, failure to adequately cross-examine and impeach Paul Skalnick, waiver of speedy trial, failure to have Dailey testify, failure to properly object to prejudicial evidence, failure to adequately urge motion for judgment of acquittal, failure to investigate witnesses, trial counsel was unfamiliar with the case, failure to hire and utilize an investigator, and cumulative error. Ground 2, Dailey was denied an adequate adversarial testing at the sentencing phase of his trial in violation of the 6th, 8th, and 14th Amendments. Trial counsel failed to adequately investigate and prepare mitigating evidence and to adequately challenge the state's case. As a result, the death sentence is unreliable. And his initial, sub-grounds are failure to investigate or present mitigating evidence, failure to utilize or adequately prepare a mental health expert, failure to object to or offer an alternative heinous, atrocious, and cruel instruction, failure to object to prosecutorial misconduct, and again, cumulative error. Ground 3, Dailey was deprived of his right to due process and equal protection under the 14th Amendment, as well as his rights under the 5th, 6th, and 8th Amendments, because his trial counsel failed to prepare a competent mental health professional to evaluate Dailey. As a result, Dailey was denied his right to adequate mental health assistance under Akey versus Oklahoma. Ground 4, Dailey was deprived of his right to due process under the 14th Amendment to the United States Constitution, as well as his rights under the 5th, 6th, and 8th Amendments, because the state withheld evidence which was material and exculpatory in nature. I've got 4A is blank because it could have been a misnumbering in the petition, but I didn't get a chance to do any digging. B is Paul Skalnick, and C is investigative notes of the Indian Rocks Beach Police Department. Ground 5, newly discovered evidence establishes Dailey's conviction and sentence were in violation of the 8th and 14th Amendments, and he cites evidence about James Leitner, who's one of the inmate witnesses, Oza Shaw, Jack Piercy, and Gail Bailey. Dailey was ground 6. Dailey was denied his fundamental right to a fair trial due to prosecutorial misconduct, and that was in the introduction, opening, closing statements with regard to Paul Skalnick and other misconduct. Dailey, ground 7, was denied his rights to due process under the 14th Amendment and his rights under the 5th, 6th, and 8th Amendments because the state either knowingly presented or failed to correct material false testimony, and that was, again, A as blank because it may be misnumbering. The B is Paul Skalnick and C is Gail Bailey. Ground 8, Dailey's sentence of death is disproportionate to that of his co-defendant, making a sentence arbitrary, capricious, and disparate, and invalid in violation of the 8th and 14th Amendments. Ground 9, the trial court committed fundamental error by instructing the jury regarding the aggravating factor of heinous, atrocious, or cruel. The jury instruction was unconstitutionally vague in violation of the 8th and 14th Amendments. 10 is Florida's capital sentencing statute is unconstitutional on its face. 11, Dailey's sentence of death violates the 5th, 6th, and 8th Amendment because the penalty phase jury instructions were incorrect under Florida law and shifted the burden to Dailey to prove that death was inappropriate. Ground 12, Dailey's sentencing jury was misled by comments, questions, and instructions that unconstitutionally and inaccurately diluted the jury's sense of responsibility towards sentencing in violation of the 8th and 14th Amendments. Ground 13, the rules prohibiting Dailey's lawyers from interviewing jurors to determine if constitutional error was present violates equal protection. Ground 14, execution by electrocution is a cruel and unusual punishment. Ground 15, Dailey's trial court proceedings were fraught with procedural and substantive errors, which cannot be harmless when viewed as a whole, since the combination of errors deprived him of the fundamentally fair trial guaranteed under the 6th, 8th, and 14th Amendments. An order to show cause was issued on February 14, 2000 on the amended motion to vacate. The state responded to that order of show cause on May 11th. A Huff hearing was held, and that's to determine whether Dailey is entitled to an evidentiary hearing on any of his claims. The court found that he was entitled to a hearing on grounds 1, 2, 3, 4, 5, 6, and 7. And then the right to address the remaining 8 claims was reserved. An order of disqualification was entered by the trial judge, Judge Pennick, I believe, on September 26, 2000. And that was because Dailey's former trial counsel, Henry Andringa, is now a county judge of the 6th Judicial Circuit. Given that fact, the court does not believe that it is appropriate for it to pass upon the credibility of a fellow judge who presides within the same circuit and courthouse. More importantly, the possibility that the defendant may reasonably perceive that he would not receive an impartial review of his claim requires this court to disqualify itself from reviewing this matter. And I just want to pause. That is, before Dailey even asked, the judge disqualified not only himself, but the whole circuit, and asked the Florida Supreme Court the chief judge of the circuit asked the Florida Supreme Court to appoint someone from another circuit. So when we see things about this process not being fair to Dailey. And I think he alluded to that in his 2020 interview, if I'm not mistaken.
I believe so.
Because, those are not the first attorneys that have gone to work for him. These attorneys went to work for him, as you just heard, in the grounds that they raised on his state post-conviction. So anyway, as a result of that disqualification on October 18, 2000, the Honorable Jack Espinosa Jr. was appointed as the temporary judge of the 6th Judicial Circuit to hear all matters connected with the case on the grounds that the ascension of Dailey's trial attorney to a judgeship created a conflict of interest with the judges of the 6th Judicial Circuit. A second Huff hearing was held on November 19, 2001. An order was issued on August 29, 2002. It's 72 pages, and it went through Dailey's allegations and ordered a hearing on grounds 1, 2, 3, 4, 5, 6, 7, 8, and 15, and denied grounds 9, 10, 11, 12, 13, and 14. Then evidentiary hearings were held on March 19, 2003, November 7th, 2003, December 11th, 2003, June 29th, 2004, and November 5th, 2004. On July 14th, 2005, an 82-page order was issued, and that found basically that Dailey failed to introduce any evidence or present any testimony or argument supporting his claims during the evidentiary hearing held in this matter, that he failed to prove prejudice as required by Strickland and Downs in relation to his ineffective assistance claims, that he abandoned many claims for unspecified or strategic reasons, that many of his ineffective assistance claims were procedurally barred because they were raised on direct appeal and could not be relitigated in post-conviction using different arguments. Many of his claims were conclusively refuted by the record, and his cumulative error claims were without merit. So his relief was denied, and he had 30 days to appeal. That was filed on the 20th of July. It was issued on the 14th of July. He filed a notice of appeal to the Florida Supreme Court. The issues he raised were that the lower court erred in denying his claim that he was denied his fundamental right to a fair trial in violation of the 5th, 6th, 8th, and 14th Amendments due to prosecutorial misconduct. The lower court erred in denying his claim that he is entitled to a new trial, either because the state violated the mandates of Giglio and knowingly put forth false testimony from Paul Skalnick, or newly discovered evidence establishes that Paul Skalnick is an incredible liar and his testimony cannot sustain Dailey's conviction. Although it's not just his testimony, sweetie. The lower court erred in denying Dailey's claim that newly discovered evidence from Oza Shaw and Jack Piercy entitles Dailey to a new trial. Because remember, in 1993, Piercy gave a sworn statement that exonerates Dailey.
Mhm.
And issue 4, Dailey's counsel were ineffective for failing to use phone records to impeach Gail Bailey, failing to cross-examine Skalnick about the facts and circumstances of his pending charges, and failing to use newspaper articles to impeach Skalnick, and in failing to call Dailey to testify. He also filed a petition for writ of habeas corpus on March 21st, 2006, directly to the Florida Supreme Court, and he challenged the indictment against him for the first time. He challenged Florida's death sentencing statute. Basically, those are the two areas that he challenged on that writ of habeas corpus. An order entered on April 7th, 2006, requested a response to Dailey's petition by June 23rd. The state responded. Oral argument was held on both matters because these were filed under two separate matters, and a decision was issued on May 31st, 2007. Appellant inmate was convicted of first-degree murder and sentenced to death. He sought post-conviction relief under Florida Rule of Criminal Procedure 3.850, alleging ineffective assistance of counsel, prosecutorial misconduct, and newly discovered evidence. After conducting an evidentiary hearing, the Pinellas County Circuit Court, Florida, denied his petition. He appealed and petitioned for a writ of habeas corpus. 3 prisoners testified the inmate confessed to murdering a teenage girl. The High Court held that as the prosecutor merely stated her belief that the state satisfied its burden of proof, defense counsel's failure to object was not deficient. The prosecutor's alleged improper vouching for a witness was in fact a fair comment in response to defense counsel's attack on the witness's credibility, as documents signed by a witness did not prove he testified falsely at trial. The prosecutor testified that she believed the witness's testimony was truthful, and the documents contained unsubstantiated allegations written a year after the trial. The inmate's Giglio and newly discovered evidence claims were properly denied. A statement was properly excluded as uncorroborated hearsay, which failed to qualify as a statement against interest under Florida statutes because the declarant never admitted to committing the murder or any other crimes. The trial court properly refused to credit a witness's recantation of his trial testimony regarding the habeas petition, as the inmate's conviction was final before Ring versus Arizona was decided. His claim based on Ring lacked merit. The High Court affirmed the trial court's denial of the inmate's post-conviction claims and denied his petition for a writ of habeas corpus. Dailey filed a motion for rehearing, which was denied on September 10th, 2007. So, this is the first wave of attack on Paul Skalnick. Basically, Skalnick started filing a bunch of pro se motions in his criminal actions in Texas and Florida, and Dailey's attorneys got their hands on those and tried to use those to paint his testimony at trial as having been false. It didn't work. But get used to it. You're going to keep hearing Skalnick's name.
Right.
All right. So now he goes to federal habeas, and I'm just going to kind of skip over the federal habeas because it's essentially the same claims as those raised in the state proceedings. He filed his petition for writ of habeas corpus on October 18, 2007. He did argue many of the grounds for error that were found by the Florida Supreme Court on direct appeal as entitling him to relief in federal court. But the federal court did not agree. I'm not going to go through the grounds. He did have a motion to appoint counsel. The state appeared. He filed a motion to amend or correct his petition. The state filed a motion to dismiss and a memorandum in support. He sought to supplement the record to file additional records regarding Skalnick from the state post-conviction record that apparently weren't in the federal records. A notice of hearing was issued on the motion to supplement, and on September 29th, 2008, the court ruled that the motion to dismiss was granted to the extent that grounds 1 in part, 2 in part, 3 in part, 6 in part, and 7 are dismissed as procedurally barred, and ground 5 is dismissed for failure to allege a federal constitutional claim. Respondent was given 45 days to file a response addressing the merits of the remaining claims in the petition. and then lists the claims that he needs to respond to. And he had 30 days from the date of respondent's response to file a reply. An order issued on April 1st, 2011, denying his writ of habeas corpus and directing the clerk to enter judgment against petitioner. Certificate of appealability and leave to appeal in form of pauperis were denied. The judgment issued on the 4th of April. He filed a motion to alter the judgment or correct it, and an order issued on March 29th, 2012, granting in part petitioner's motion to vacate solely to the extent that the final judgment against petitioner is vacated to allow an amendment to add the claim of ineffective assistance of counsel and to correct the Scrivener's error in docket number 38, page 23, note 10, misidentifying Piercy as Pearson. For the reasons discussed, petitioner's claim of ineffective assistance of counsel for failing to object to the prosecutor's argument does not warrant relief and is therefore denied. The April 1st, 2011 order therefore is amended to reflect the denial of this ineffective assistance of counsel claim and to correct the Scrivener's error. And then there was an order. It's getting dark in here, y'all, so I'm having a tough time. The lights over my table don't work as well as they should, so I need to get a little lamp.
Get you some LED bulbs.
So I'm gonna definitely, when I'm at Walmart this week, I'm definitely grabbing a lamp to put on this table. So I'm having a hard time reading. And the judgment was entered denying his writ. He filed a notice of appeal on April 24th, 2012. That went to the 11th Circuit Court of Appeal, docket number 12-12222. He was represented by the same attorney, David R. Gimmer. An order was entered on the 26th of April denying his request for a COA and IFP status. He filed another motion to proceed in form of pauperis and a motion for a certificate of appealability. On July 19th, 2012, that was granted, but the COA again was denied. He filed a motion for reconsideration. That was also denied. And he filed a request for extension of time to the U.S. Supreme Court, which was granted. He filed his writ under docket number 12-8921 on February 21st, 2013. Conference was held April 26, 2013, and the petition was denied on April 29, 2013. Then clemency proceedings were held on September 10th, 2013. His attorneys also filed a brief in support on October 24th, 2015. That proceeding, clemency in Florida, is a little odd because I think what happens is when you exhaust your initial state and federal relief, they have a clemency proceeding and you can file in support of clemency, and then it just sits until the governor is asked later to issue an execution, a death warrant. That is what it appears to be, because there doesn't appear to have been any decision on clemency in 2015. His attorneys went back to state court. At this point, he's being represented by Capital Collateral Regional Counsel of the Middle District, James V. Vigiano, Chelsea R. Shirley, Maria E. Deliberato, and Julissa R. Fontaine. They go back to the 6th Judicial Circuit. Now they're before Judge the Honorable Frank Casada by order of assignment dated January 19, 2017. They file a successive motion to vacate death sentence. basically challenging his death sentence under Hurst versus Florida. The state files an answer. A motion to change venue is filed, basically arguing that Henry Andringa was a judge of the 6th Judicial Circuit at the time of his retirement. A response to the motion for change of venue was filed by the state, arguing that Dailey's current post-conviction motion does not involve ineffective assistance of counsel claims. It involves a legal issue based on Hurst versus Florida. Since the prior post-conviction hearing, Judge Andringa has retired and is now a senior judge. A case management conference was held on February 20th, 2017. The motion for change of venue was denied on February 21st, 2017, because finding the request was premature because an evidentiary hearing has not been granted by the court. The motion does not allege a claim that merits a change of venue, and there's no legal basis for this court to recuse itself from these proceedings, and neither party has filed a motion to disqualify this court. A motion to hold successive post-conviction motion in abeyance was filed on March 21st, arguing that the state was filing a writ on Hurst post-Supreme Court version, and therefore he wanted to hold his writ in abeyance while the Supreme Court decided whether to take that case and what they would decide on it. The state responded, arguing that a pending petition for writ of certiorari provides no basis whatsoever for holding Dailey's motion in abeyance, as there is no precedential value for the staying of a case when a petition has been filed with the U.S. Supreme Court. The Florida Supreme Court has consistently and unequivocally rejected relief in cases where the murder conviction and sentence of death were final prior to the issuance of Ring versus Arizona. Dailey is not entitled to Hurst relief because Hurst does not apply to him. The defense obtained an affidavit from former retired Judge Andringa, who also was, by that time, I believe, married to Dailey's prosecutor.
Oh, wow.
Talk about as the world turns in Peyton Place.
Right.
Because
That's
she
pretty
was
crazy.
deposed by Dailey's attorneys, and her name at that time was Beverly Andrews Andringa. So I will do some more digging on that aspect, and we'll talk about that.
Please do. I'd like to know more about that.
And hey, Lisa, sorry, I don't want to get off on a total tangent because I know I missed the last episode, but what was the motive for this killing? Were they having a relationship? Was it random? I mean,
well, she knew Dailey and Piercy because they had partied with them before.
Okay, because there were quite a bit of difference in age, because the victim was 14, right? And he was, I was trying to do the math, but he wasn't.
He was 39.
Okay, so the age difference is pretty big. That's what's kind of weird.
He had a daughter her age.
I gotcha.
Okay. And the motive, I believe, was he attempted to have sex with her, and she either A, turned him down, or B, fought him off.
Gotcha. So it was kind of a sexual assault.
Little wisp of a thing, and he's a 6'2" big guy.
Gotcha.
And she was rejecting his advances even to dance earlier as well. And it was also stated that also Dailey was acting weird.
Yeah. So they obtained an affidavit from him in support of Dailey's motion to vacate. The state filed a motion to strike that affidavit, arguing that the affidavit introduces speculative theories as to how his former counsel would have tried the case in a, quote, post-Hurst landscape, unquote. It would be inappropriate for the court to consider the contents of the affidavit in determining the outcome of the purely legal claims. A final order denying his successive motion to vacate was entered on April 13th, 2017. Basically, it was denied, and the court ruled not only, it ruled on the merits as well, and basically found that all of his arguments regarding retroactivity were not solid arguments, and he wasn't entitled to retroactive application because his death sentence became final before Ring was even decided. And Ring is what changed how Florida and Arizona had to conduct death penalty cases, because Arizona was kind of similar. The jury gave a recommendation, but the decision was ultimately up to the judge. So they denied his motion to hold the successive petition and motion in abeyance. They denied his motion to vacate, and they dismissed the motion to strike as moot, and basically told him what his appellate rights were. So then he filed a motion for rehearing. That was denied on May 12th, 2017. He filed a notice of appeal. He goes back again to the Florida Supreme Court. He filed a second successive motion to vacate judgments of conviction and sentence in both the Florida Supreme Court and the Circuit Court. And he filed a motion for relinquishment of jurisdiction by the Florida Supreme Court to let the state court, the Circuit Court, handle the second successive motion. That was granted on September 14th, 2017. And it went back to the 6th Judicial Circuit. So the appeal of the initial motion to vacate was basically obeyed. A joint motion for extension of time was granted on December 20th, 2017 for the completion of the relinquishment proceedings. The relinquishment ended on April 11th, 2018. An order to show cause was issued on April 12th, 2018. Appellant shall show cause on or before May 3rd, 2018. Why the trial court's order should not be affirmed in light of this court's decision in Hitchcock versus State, docket number SC 17-445. Response is limited to 20 pages. Appellee may file a reply on or before May 18, 2018, limited to no more than 15 pages. Appellant may file a reply limited to no more than 10 pages on or before May 29th. Dailey and the state each filed their responses to motion to order to show cause, and Dailey filed his reply on May 28th. The opinion was per curiam. It issued on June 26, 2018. After reviewing Dailey's response to the order to show cause, as well as the state's arguments in reply, we conclude that Dailey is not entitled to relief. Dailey was sentenced to death following a jury's unanimous recommendation for death. On appeal, this court reversed Dailey's death sentence and remanded for resentencing before the trial judge. On remand, the trial judge again sentenced Dailey to death, and Dailey's sentence of death became final in 1996. Thus, Hearst does not apply retroactively to Dailey's sentence of death. See Hitchcock. Accordingly, we affirm the denial of Dailey's motion. The court, having carefully considered all arguments raised by Dailey, we caution that any rehearing motion containing re-argument will be stricken. It is so ordered. Now, Judge Pariente issued a concurrence, which is more of a dissent. He concurs in the result with this opinion. In this case, it is clear that Dailey's penalty phase jury considered invalid aggravating factors in recommending a sentence of death. Therefore, if Hearst applied to Dailey's case, this court could not rely on the jury's unanimous recommendation for death to determine that the Hearst error was harmless beyond a reasonable doubt. Even more, when this court remanded for resentencing, Dailey's sentence of death was reviewed by a single trial judge alone. Thus, as a result of this court's arbitrary framework for determining the retroactivity of Hearst, Dailey remains under an unconstitutionally unreliable sentence of death. The mandate issued on July 12, 2018. Dailey then filed a motion for extension of time at the U.S. Supreme Court, which was granted on August 27th, 2018. He filed his writ on November 19th, 2019, presenting the following questions. Does the Florida Supreme Court partial retroactivity decision, which limits the class of death sentence individuals entitled to a jury determination of their death sentence pursuant to Hearst versus Florida, violate the 8th and 14th Amendments to the United States Constitution? Does the partial retroactivity formula employed for Hearst errors in Florida violate the Supremacy Clause of the United States Constitution in light of Montgomery versus Louisiana? And does the Florida Supreme Court holding that a Hearst error is per se harmless, where a jury issues a generalized unanimous recommendation for death after receiving instructions that the judge would make both the findings of fact necessary for a death sentence and render the final decision on the death penalty, contravene the 8th Amendment under Caldwell versus Mississippi? A conference was held and the petition was denied on January 22nd, 2019. All right, so it is getting more and more difficult for me to read. My apologies. So what we're going to do is we're going to pick up the next successive, which is the second one that he's already filed, that we briefly touched on. We're going to continue that process in our next episode.
Okay.
After Lisa has a lamp.
Sounds good.
So that she can read.
read.
Because I'm looking at 10 pages and my eyes are killing me. So, all right. So I'm going to put that aside. So we're going to jump a little bit ahead now into September 25th, 2019. The process in Florida for death sentence is the AG requests the governor to issue the death warrant. So the AG, at the time, her name was Moody, requested DeSantis to issue the death sentence. Obviously, this is also done by email because the same day, the 25th of September, DeSantis issued a letter to the warden transmitting the death warrant, setting Dailey's execution on Thursday, November 7th, 2019 at 6:00 p.m. And at that point, that's when DeSantis found that executive clemency is not appropriate after reviewing the proceedings and the Dailey's submission. Brain went blank. At that time as well, based on their procedure, the Florida Supreme Court on September 26th issued an order that said that because the governor has signed a death warrant for the execution of James Milton Dailey at 6 p.m. Thursday, November 7th, 2019, we direct that all future proceedings to this case be expedited. The proceedings pending in the trial court, if any, shall be completed and orders entered by 3:00 p.m. Wednesday, October 16th, 2019. We hereby set the following briefing schedule for any proceedings that may come before this court. The notice of appeal shall be filed by 10 a.m. Thursday, October 17th. The record on appeal shall be filed by 3 p.m. Thursday, October 17th. The initial brief on the merits shall be filed by 3 p.m. Monday, October 21st. The answer brief on the merits shall be filed by 3 p.m. Wednesday, October 23rd. The reply brief on the merits shall be filed by 3 p.m. Thursday, October 24th. Oral argument, if necessary, will be scheduled at a later date. Copies of any pleadings filed by counsel in the trial court and the federal court shall be sent via email simultaneously with filing to the other courts to the following address. And it gives an address where there's a death warrant, an active death warrant. And I think that's pretty much there's additional proceedings. So that's pretty much it. We're going to stop with the death warrant. And we will pick up with his second successive motion to vacate and the ones that followed it after that.
Sounds good.
All right. So any thoughts, any questions?
Yeah, I don't think this is going to go well for him. I
Well, you'd be surprised.
well, clearly he's still, again, I don't mean to spoil it for anyone. He's still alive, but I just don't.
Yeah.
It may be a long time. He may die of natural causes before he sees a death penalty. I don't know. That'll be determined. We'll see.
Yeah.
But as far as him, getting out, I don't think that's going to happen.
Yeah. Well, as I said in my email, now it becomes, if you think it was convoluted and complicated before, oh my child.
And from a PR perspective, when you see the guy, you don't see a hardened criminal. You see he looks like a soft grandpa who gives you a Werther's original candy.
Uh-huh.
But of course, I mean, which is a far cry to how he looked. I mean, not that how you look determines it, but he just doesn't look like a hardened criminal. But looks can be very deceiving.
Yeah.
Clearly.
Yeah, definitely.
Well, that's the thing with all. I mean, again, I get the point that you don't want to bias juries, but it's always amazing. You'll look at somebody convicted of a crime during their trial or after they're convicted. You're like, oh, that looks like such a nice person. Then you see them when they were arrested or before, and they looked completely different.
Mm-hmm.
Yeah, especially compared to Piercy. Like, if you look at him, he looks like a criminal. I mean, I hate to stereotype it, but he looks like a criminal compared to Dailey. But again, we can't judge and base things just solely on that. We have to, of course, look at the evidence and see where that takes us. And, everything points to Dailey being the major factor here in the crime being committed.
Mm-hmm.
Right.
All right. Well, that is, while I could still read, and my apologies because I've managed. It's just getting dark earlier. I think, Kyle, the last time we recorded, it was still lighter than it is right now.
Yeah, I think it was maybe before daylight savings or Central Time kicked in. Maybe.
That's probably before standard time.
Yeah, that big jump. It's crazy because it'll go all of a sudden it's dark at 5 o'clock.
Yeah, and very dark at 5 o'clock. I will have you know. So, all right. Well, I will. Thank you, Rick, for joining us, and of course, you're welcome when we conclude this. You're welcome to come back.
If you'll have me, I'll be here.
I will certainly. I think that's a great idea.
Excellent.
Excellent. It was great to talk to you guys. Y'all have a wonderful week.
Thanks, Kyle. You too. Happy holidays and Happy New Year.
Happy holidays, everyone.
Yeah, take care.
All right. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans, and our guest co-host, Rick Mullinax. If you like the show and want to know more, you can find us on Facebook or follow me on X at @O'BrienLN. Join us in 3 weeks for Season 4, Episode 1, State of Florida versus James Milton Dailey, Part 2. We'll conclude our look at the case against Dailey and his new claims in state and federal court in an effort to win a stay of execution and ultimately a new trial. We want to wish everyone a happy holiday season and a safe and happy new year. Until we talk to you again in 2025, have a great 3 weeks and stay safe.